Okay, reading the Model Code of Professional Conduct, Model Rules of Professional Conduct, and I'm in Rule 1.15, Safekeeping Property within the Client-Lawyer Relationship section. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from the lawyer's own property. Funds must be kept in a separate account maintained in the state where the lawyer's office is situated or elsewhere with the consent of the client or third person. Other property shall be identified as such and appropriately safeguarded. Complete records of such account funds and other properties shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of representation. That's the records relating to the funds and other property. B, a lawyer must deposit the lawyer's own funds in a client trust account for the sole purpose of paying bank service charges on that account, but only in an amount necessary for that purpose. So a lawyer may do that. C, a lawyer may deposit into a client trust account legal fees and expenses that have been paid in advance to be withdrawn by the lawyer only as fees are earned or expenses incurred. D, upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person, except as stated in this rule, or otherwise permitted by law or by agreement with the client. A lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and upon request by the client or third person shall promptly render a full accounting regarding such property. E, when in the course of representation a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claims interest, the property shall be kept separately by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. Next, Rule 1.16, declining or terminating representation. A, except as stated in paragraph C, a lawyer shall not represent a client or where representation has commenced, shall withdraw from the representation of a client if 1, the representation will result in violation of the rules of professional conduct or other law, 2, the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or 3, the lawyer is discharged. B, except as stated in paragraph C, a lawyer may withdraw from representing a client if 1, withdrawal can be accomplished without material adverse effect on the interests of the client, 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 2, the client persists, 3, the client has used the lawyer's services to perpetrate a crime or fraud. 4, the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. 5, the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. 6, the representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client. Or 7, other good cause for withdrawal exists. C, a lawyer must comply with applicable law requiring notice to or permission of a tribunal when terminating representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. D, upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled and refunding any advance payment or fee or expense that has not been earned or incurred. The lawyer may retain papers relating to the client to the extent permitted by other law. Second to last section is 117, sale of law practice. A lawyer or a law firm may sell or purchase a law practice or an area of law practice goodwill if the following conditions are satisfied. A, the seller ceases to engage in the private practice of law or in the area of practice that has been sold in the geographic area. In the jurisdiction, a jurisdiction may elect either version in which the practice has been conducted. B, the entire practice or an entire area of practice is sold to one or more lawyers or law firms. C, the seller gives written notice to each of the seller's clients regarding 1, the proposed sale, 2, the client's right to retain other counsel or to take possession of the file, and 3, the fact that the client's consent to the transfer of the client's files will be presumed if the client does not take any action or does not otherwise object within 90 days of receipt of a notice. If a client cannot be given more, the representation that of that client be transferred to the purchaser only upon entry of an order so authorizing by a court having jurisdiction. The seller may disclose to the court in camera information relating to the representation only to the extent necessary to obtain an order authorizing the transfer of a file. And D, the fees charged clients shall not be increased by reason of the sale. All right, I believe the next section is the last section, which is duties to prospective client. A person who consults with the lawyer about the possibility of forming a client-lawyer relationship is with respect to a matter is a prospective client. B, even when no client-lawyer relationship exists. A lawyer who has learned information from a prospective client shall not use or reveal that information except as Rule 19 would permit within the respective a lawyer shall not subject paragraph B. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or a substantially related matter, and if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D. If a lawyer is disqualified from representation under this paragraph, no section in a firm with which that lawyer is associated may knowledgeably undertake. Undertake or continue representation in such a manner, except as provided in paragraph D. D, when the lawyer has received disqualifying information as defined in paragraph C, representation is permissible if 1 to 1 is both the affected client and the prospective client have given informed consent, confirming in writing to explicit, or 2, the lawyer who received information reasonable measures to avoid exposure to more disqualifying information than was reasonably to as relevant in today's case. I, Romanet 1. The disqualified lawyer is timely screened for any participation in the matter and is apportioned no time of the fee therefrom. And 2, Romanet 2, written notice is promptly given to the prospective client. That's all the rules in Article 1.